Fast forward, you come out channel so Haji Politics Avenue. Podcast source training because making headlines. No Jembre now it be Exmo. Ni dem young Braximo, Mr. Say young Queen Simon, ya Queen Sima, a Law.Martin Kpebu, and a mano case what me school a year remove justice to Kunung with legal wisdom on your enyasem koto akra. At this point in time, yen sembre ye bobo running Simu, near when ye Connie Barbara one nena pam for transia or more air boy in Chrum. Aha GH Politics Up.
TV3, we're live on 3FM 92.7, also on TV3. Gentlemen, okay, we're back. Okay, we're live on TV3 Ghana on Facebook and on DSTV channel 279. We're all across the world on 3news.com. The Attorney General is at the Supreme Court asking the court to answer a number of questions. And it's on the back of these reliefs that the former Chief Justice is seeking in her latest application that we discussed last week, that there should be a declaration that the president is devoid of power to remove a justice of the Superior Court from office without recourse to the mandatory procedure set out in Article 146. And this, a declaration that jurisdiction to hear a petition for the removal of a justice of the Superior Court from office lies with a body properly so constituted under Article 1464 of the 1992 Constitution. And this is the crux of the issues, the questions that the Attorney General is asking the Supreme Court to answer. The former Chief Justice is seeking a declaration that the warrant of removal executed by the President dated 1st September 2025 purporting to remove her from both the office of Chief Justice and the office of a Justice of the Superior Court of Judicature is unlawful, null, void, and of no effect. And so the Attorney General is at the Supreme Court asking a number of questions. One, that whether a person may retain his or her previous judicial office, if any, upon appointment to the office of the Chief Justice, and two, whether the Chief Justice's membership of the Superior Court of Judicature is ex officio to the office of the Chief Justice. And finally, whether a person may retain his or her membership of the Superior Court of Judicature upon removal from the office of the Chief Justice. Now, this is why the Attorney General is at the Supreme Court. Will this move or decision by the Attorney General to seek this particular intervention or interpretation by the Superior Courts, that's the Supreme Court, bring some finality to the matters at play? I'll start off with you.
First of all, there's an inherent incompetence in the judicial review application that has been filed. When you go for judicial review, you are inviting the court to exercise what we call supervisory jurisdiction of the court. You cannot, in invoking supervisory jurisdiction, ask for what we call declarative reliefs. So the declarations that they are seeking within the context of a judicial review application is incompetent. The Constitution is clear as to what powers can be exercised. So if you go to Article 161, I would read, it gives you 1, habeas corpus, certiorari, mandamus, prohibition of quo warranto. Those are the only reliefs you can seek. So declarative reliefs are not one of them. Secondly, legally, and this is the confusion that I've seen so many people make in some of this discussion, it is presumed that the Chief Justice is at the same time a Chief Justice and then a Justice of the Supreme Court. She's not. Those are different offices. The Chief Justice position is a fresh appointment. It's not an elevation. A person can be appointed from the High Court to become a Chief Justice. So that when you say that the person is then removed as Chief Justice, the person should go back to the High Court. That's what they are suggesting. Once you are appointed to the office of the Chief Justice, every previous appointment you have held has ceased. You no longer exist as another additional judicial officer. So
it's not a position that you hold in two.
No, you don't hold two positions at the same time. And I've seen this being spoken about, like so many confusions. No. And when a justice is appointed, when Justice Kpebu was appointed from the High Court to the Supreme Court, he didn't at the same time hold the High Court position together with the Supreme Court position. It's extinguished, dead, gone. So in the case of, former Chief Justice Torkonoo, she was a Supreme Court justice, And then when that ended, when she was appointed, by going through parliamentary vetting and that becoming ratified, she then assumed a new office. So she only exists as a Chief Justice. Having been removed as Chief Justice then that's it. You don't go back and say that the previous office I held before I became a Chief Justice must be reinstated. There's nothing to reinstate. So that's the confusion here. I'm very happy that the Attorney General has decided that he will take this matter to the Supreme Court. Because there's also some confusion that people were suggesting that this is settled matter. But it's an inherent confusion where people think that an obiter reasoning of the court, when you say obiter, things that the judges say along the way is the ratio or the main reason. If I go to court to ask the court whether, the fact that this process was publicized would invalidate the process, there's a specific question that the court is answering. Even in terms of talking, the judge says, and I also think that once you are removed as Chief Justice, you have also been removed as Supreme Court Justice. It is not what the court was deciding. It was something they said by the way. So perhaps for us to get complete clarity on this, we have to understand how law functions. A new appointment is made when the person is appointed as Chief Justice. The person can accept or decline that job as Chief Justice. It's not an add-on to their role. It's a role in itself. So when you look at the constitutional structure, it says that the Supreme Court is made up of the Chief Justice and the justices of the Supreme Court. So these are separate. It doesn't say that it's made up of justices of the Supreme Court, one of whom has an additional responsibility as. No. It's a different office on its own. And you see that the Chief Justice then, by reason of Chief Justice, is part of the High Court, is part of the Court of Appeal, is part of the Regional Tribunal. All different sectors of the court system. So when that office then, you have been removed from the office, your ability to belong to the Supreme Court, your ability to belong to the Court of Appeal, the High Court, and the Regional Tribunals is all gone. So that's for me at least, that's the reasoning I take in terms of how we understand the structure that the Constitution has created around this issue.
And say as for the obiter debate, I think we settled it last week on this same platform. So there isn't much to. But then again, you mentioned that this move of judicial review, in your view, based on at least the references of the law that you indicate, the Attorney General's decision to seek interpretation will bring some finality to this. Is it on the same path?
Absolutely. Look, there was a release from her camp, and one portion struck me, and I think I just want to read it. It's very short. It says, if someone wants to destroy the work of a judge of significant repute of many decades and her accomplishments, the least that should be done in a constitutional republic is to at least accord her the basic rights she is entitled to as a citizen. She has a right to know the findings against her and the reasons for her removal in a proper written and complete report, so she can avail herself of any remedies available. The point here is it possible that the Chief Justice has been removed and she doesn't have a written report of the reasons why she was removed?
Is that a case?
That is the question. Okay, because I am told that she didn't get a report to the prima facie case, so she couldn't properly, if she doesn't get it, she can't prepare her defense. She's entitled to that. She didn't get a written report of the reasons why she's removed. These are fundamental. And so that's why I read. If it is true, and I'm reading from what Honorable Ayikwe Otu published, please get it.
He sent that to me.
Good, so check. Is that true? If it is true, then we are making a bad mistake. And you see, that's why I say, if the new CJ Bafo body, after all his work, is going to ascend onto this seat, let it not go under this cloud. That you remove, you understand what I'm saying? Can it be that you didn't give her the prima facie report, that you haven't given her a report of why she's been removed? Now, the arguments that Oliver has just made, they are arguments. And like you said the last time, we had all kinds of arguments. I made a point here the last time that this table is not the Chief Justice, it's not the Supreme Court. So let that matter go before the justices, the lords of law, and let them determine it, because there is merit to it. So when you add the fact that...
So I thought you said there were precedents. No. Yeah,
so we argued the precedents last week. Yes. So for instance, so we've argued it. There were orbiters, and then Martin was able to show that Modibo actually spoke to it as a substantive issue. I was able to show that Article 146 Clause 2 says something which is directly opposite what Modibo said. So in law, we have something called per incuriam, where a judge makes a ruling that is directly in aberration with the law. So the issues are clearly there. Now, seeing that she has a cause, and she has not exhausted the legal remedies available to her. And somewhere also I read something which is very important. This is the Chief Justice. If anybody has a moral responsibility to fight for what is right procedurally, it is her. You have a situation where people say, oh, they've removed her, she should just go home. No, I said last week, and I repeat, this fight is useful for us more than her. But for whatever it's worth, this is a career, an illustrious career. You don't just get up and throw it into the dustbin. Give the woman at least what she is justly entitled to, and let her go through the processes and fight a case. There are about, I hear 4 cases pending on this matter. Yeah. The determination of which can move this here, there. People think she's trying to come back as Chief Justice. I don't see how that is possible. All right? Okay. But the truth is that if there are 4 cases pending, look, Oliver, for instance, sued on these people who were, deported here. All of a sudden, I heard that they have been sent back. If there's a matter in court, and the matter hasn't been determined, and I don't know the facts, so you can tell me. But if it was in court, hasn't been determined, we haven't had finality and a judicial pronouncement of it, and then the executive just goes ahead and overreaches the matter, it is wrong.
And that's why we asked the same question. The answer was that it was a process in motion, so it wasn't as though they were going to stay here.
But a judicial process holds things. He has the facts, so he can correct me on that. But where I'm going is that when somebody has a matter before a court, you hold your hand. And in the situation where this has to do with the courts themselves, a Chief Justice, it is a bit worrying to me that it's almost, ignored that she has matters in court. Again, we keep going back to the Demolovo case. We have a matter in court for 2 years, it's not heard, and then when it comes, we win the case, but then it's already moot. Okay, it is worrying. It is worrying, and I think we should do something about it. If you read the statement that they put out, okay, it casts a shade, and I think we should get rid of these things and then move forward with a clear mind.
I acknowledge what Niaiko, to the lead counsel for the former Chief Justice, Torkonoo, has sent me. In fact, portions of which you have referenced. Yes. So I have that statement from Niaiko to he's sent that to me as well. Law.Martin, Kpebu, this...
Maybe you should put him on the line.
Yeah, but this decision, because of time, but this decision to seek this interpretation, the questions that the Attorney General is asking of the Supreme Court, would it settle the issues that Kofi Bento, for instance, raises, and what the counsel for the former Chief Justice is raising, specific to the entire process of whether or not she can still, or the warrant of removal affects both portfolios as a Justice of the Superior Court and a Chief Justice?
Yeah, okay. As for the removal affecting both, there is no doubt at all that it does. That one, there is no doubt. And that resolves most of the issues that have been raised. Because, you see, last week we refer and we repeat. The Supreme Court said in the Ejechum case that when you are removed as a Chief Justice, by implication, you are removed as a Supreme Court judge. That's page 804. We read it.
Yes.
Modibo saying it. And then you come to Datiban also making the point. Look, before Datiban made the point that your actions as a Chief Justice affect your actions too as a Supreme Court judge, what he first did was to pull out arguments that the plaintiff had made. And it was the plaintiff who argued that when you are removed as a Chief Justice, you are removed as a Supreme Court judge. It was the plaintiff. Let's read it for emphasis. So, Oliver, sorry, I have to...
You are re-arguing last week.
Yes, because that's what it involves. Oliver, I don't know if you paid attention to this. He said, and by all means, it's not possible.
Order 55?
Sorry, no, the point that the remover, you're saying that when it's obiter, and I'm saying no.
Okay.
At 2 points, I don't agree.
Okay.
Look, this is page, if you go 773, okay, you see that a ban, he quoted verbatim the arguments that Ejechu made through Bedietuo and his father, right? He says, paragraph 12 says, the Constitution does not provide any separate and distinct grounds other than those set out in Article 146, Clause 1 for removing the Chief Justice, qua Chief Justice from office. Thus, under the Constitution, a Chief Justice cannot be removed as Chief Justice from office and remain on the bench as a Superior Court judge or as a Justice of the Superior Court. Let's repeat. It was Ejechum who argued that thus, under the Constitution, a Chief Justice cannot be removed as a Chief Justice from office and remain on the bench as a Justice of the Superior Court. That's paragraph 12, page 773, 774. So you see that the Supreme Court copied out their arguments and set out to answer. And Dateba said, look, your actions as a Chief Justice also affect your actions as a Supreme Court judge because of the ethics. I mean, we can read out that. So, Oliver, the point where you said that for you, when somebody is appointed as a Chief Justice, the office of Supreme Court judge is gone. That one, respectfully, I disagree. That's not how. No, because they say that you are a Chief Justice. Your actions as a Chief Justice also affect your ethics as a Supreme Court judge. Presumably, that Supreme Court judge office is still there.
So any act that breaches the ethics in your capacity as a Supreme Court judge also affects that capacity as a Justice of the Superior Court.
Excellent. Yes, that's what the Supreme Court
they are two separate,
said.
and the removal process should be different.
But
my issue is a procedure now. My issue is a procedure now. Was she given the reports?
Yes.
Yes.
That's a key issue.
So when it comes to that, let's read. Then Modibo said the Chief Justice, upon his removal, will by implication also lose his position as a judge. The Chief Justice, upon his removal, will by implication also lose his position as a judge. That's Modibo Okran at page 804. That's Justice Modibo Okran.
We'll put that on
and
the
before he did so, this is what he says. He says, however, an interesting inferential question arises. Since the grounds for the removal of the Chief Justice are placed at par with the removal of the other justices of the Superior Court, can the Chief Justice continue to sit as an ordinary member of the Supreme Court after being removed as a Chief Justice?
There's an error there.
Suppose
it's not at par. That's where the error is.
Oh, well,
there are two different processes.
Well,
two different processes. It's in 1462. That's what I'm saying.
Suppose he or she was
resolve this matter
due to incompetence as an administrator.
It's a very different process.
But the person had a track record as a superb judge before being elevated to the position of Chief Justice.
A Chief Justice is not an administrative office.
Let us say that he or she was simply a terrible administrator. Why cannot such a person come back to his regular Supreme Court position and continue with his outstanding judicial performance?
So, the premise is wrong. Martin, if a member of the bar is appointed as a Chief Justice, can the person sit on the Supreme Court?
Absolutely.
Yes, so the inherent in the Chief Justice is a judicial and administrative office. It's not separate. So it's not an administrative role alone. Because if I want the argument,
they're saying that.
Yeah, but you are saying that.
Is different.
Okay. That's what I'm saying. That the person is not removed. If you are removed as Chief Justice, you are removed in the administrative and judicial role. Not separate. That we should finish that one and come and remove you again as a judge.
Yes,
that's not. It can't be the case.
Exactly.
So they are separate offices. Once you are appointed to the Chief Justice, if you whatever you were before, you're no longer.
I'm not. But that one is
doesn't work.
Yes,
if they are separate offices.
Yes,
and there are separate provisions made for them. Okay.
If they're separate offices, is the Chief Justice occupying two offices at the same time?
Hear me.
No.
Give me 1 minute.
We are not in court.
Okay, let me finish. 1 minute. I don't need more than that. Oliver, your answer is here. Look, Article 128 Clause 1 says, the Supreme Court shall consist of the Chief Justice
And not
less than 9
other justices.
Adda, Oliver, Adda. So it tells you
the question is not that. The question is whether the Chief Justice Torkonoo
my quick point.
is both the Justice of the Supreme Court and the Chief Justice.
He did it.
It can only be one.
In a minute.
Martin says one thing, and that is the same thing. Oliver is saying they are two separate. And I'm saying the two of them cannot be correct at the same time. That is one. I am making a third position. The third position I'm making is that look at the law. Article 146 subclause 2 says that as Justice of the Supreme Court may only be removed. It restricts you. Now, appointments for those two offices are different. Vetting for those two offices are different. And then removal for those two offices are differently provided for. The constitution of the committee are different.
Okay.
What it tells you is that they are different and should be treated differently. But look,
thank you. I think
we have a problem.
Okay, thank you.
Let the Supreme Court deal with it.
I've been listening to Kofi Bentil on this matter, and I've been listening to Martin Kpebu, and clearly, and I've heard Oliver. They are contrasting and conflicting positions on this matter. And I think that the way and manner, then some people also go out of their way to say that this current government means harm, and that's how come they are not listening to some of the things that are being said. I mean, it's problematic because if it were the case, then the Attorney General would not have gone to the Supreme Court to seek interpretation, to bring clarity. And so, for me, it tells me that the processes have been resorted to. The outcome has led to some more conflicting views about it. And it's important that the matter is sent to the Supreme Court for interpretation, so that there will be clarity. And so, to the extent that the Attorney General has not said that, look, go to hell, we are done with you, but is going to court to still find out whether being removed as a
we sama horo itimi ko so channel no so no aso jemre e wo hada sane so bad ndi andubi edumi ne onia besen rem ne yasmo kwanson so kra GH Politics Avenue.